Picture two men standing before a colonial magistrate in 1705 Virginia, both accused of the same crime, theft of a pig valued at 10 shillings. The first man is white, a recent immigrant from England, poor but free. The second is black, enslaved, belonging to a neighboring plantation. Both admit their guilt. Both express remorse. Both are first-time offenders. The white man receives 15 lashes and is ordered to repay double the pig's value. Painful, humiliating, but survivable. He'll return to his community, his reputation damaged but his life intact. The black man. He's sentenced to have his right hand severed at the wrist, a permanent, brutal mutilation that will mark him for life, destroy his ability to work, and serve as a walking warning to every other enslaved person in the county. Same crime, same evidence, same court, radically different punishments based solely on the color of their skin. This wasn't an isolated incident or the act of one cruel judge. This was the law codified, systematic, and deliberate. In colonial America, justice wasn't blind. It had eyes wide open, carefully distinguishing between white and non-white, free and enslaved, Christian and heathen. The scales of justice didn't balance. They were deliberately weighted by race, ethnicity, and status. Today, we're exploring one of the most disturbing aspects of early American history: how colonial legal systems created and enforced a racial hierarchy through drastically different treatment of crime and punishment. What we'll discover is that American racial inequality wasn't an accident of history. It was built into the legal system from the very beginning. To understand how different ethnic groups experienced colonial justice, we must first grasp the fundamental legal framework of colonial America and how it evolved to create and enforce racial hierarchy. The English colonies in North America were established during a period when European legal thought was deeply intertwined with religious identity, social hierarchy, and emerging racial categories. Early colonists brought with them English common law, a system developed in a relatively homogeneous society where social status mattered enormously, but racial difference as we understand it today was less relevant. The challenge of colonization forced rapid adaptation of these legal principles to a radically different context, a multiracial society built on exploitation, where indigenous peoples were being displaced, Africans were being enslaved, and poor Europeans were being recruited as laborers. In the earliest years of colonization, 1607 to 1640, the legal distinctions between different groups were less rigid than they would later become. While indigenous peoples were viewed as outsiders and potential enemies, some early documentation shows them participating in legal proceedings, entering contracts, and even winning cases against colonists. The first Africans arrived in Virginia in 1619 as indentured servants rather than slaves, a temporary status they could theoretically work their way out of, just like white indentured servants. Poor Europeans, especially the Irish and later Germans, faced harsh treatment under the law but retained basic legal personhood. This relatively fluid system couldn't survive the economic demands of colonial expansion. Tobacco cultivation in the Chesapeake, rice production in the Carolinas, and sugar cultivation in the Caribbean required massive labor forces willing to work in brutal conditions for minimal compensation. Initially, colonies relied on white indentured servants, but this system had fatal flaws. Indentures expired, creating a class of poor, landless, armed white men who resented the colonial elite. Servants could complain to authorities about mistreatment, and the supply from England was limited. The solution was the creation of a racial caste system encoded in law. Beginning in the 1640s and accelerating dramatically after Bacon's Rebellion in 1676, when poor whites and enslaved blacks briefly united against the colonial elite, Virginia and other colonies passed a series of laws that transformed African indentured servitude into permanent, hereditary, racialized slavery. These weren't simply economic regulations. They were comprehensive legal codes that defined who counted as fully human under the law and who didn't. The Virginia Slave Codes of 1705 provide the clearest example of this legal architecture of racial inequality. These laws systematically stripped enslaved Africans and their descendants of legal personhood. They couldn't testify against white people in court, meaning any crime committed against them by whites was effectively unpunishable. They couldn't own property, enter contracts, or sue in court. Most critically, different crimes carried radically different punishments based on the offender's race. What would be a minor offense for a white person became a capital crime for an enslaved person. Simultaneously, other colonies developed parallel systems targeting different groups. New England's treatment of indigenous peoples created a separate legal framework based on the fiction that Native Americans were outside colonial law entirely, until they committed acts that harmed colonial interests, at which point they were subject to draconian punishment. Spanish colonies in Florida and later, the Southwest developed caste systems, elaborate racial hierarchies with distinct legal statuses for Spanish-born whites, Criollos, American-born whites, mestizos, mixed Spanish-indigenous, mulattoes, mixed white-black, indigenous peoples, and Africans. French colonies like Louisiana created their own versions through the Code Noir, Black Code. The absence of professional police forces in this period is crucial to understanding how this system functioned. Without centralized law enforcement, the responsibility for maintaining racial hierarchy fell on the entire white community. Slave patrols, armed groups of white men authorized to stop, search, and punish any black person found off their owner's property, represented the closest thing to organized policing in many colonies, and their primary function was racial control, not crime prevention. Similarly, militias that fought indigenous peoples operated under rules of engagement that explicitly denied Native Americans protections extended to white enemies. The colonial legal system also created distinct categories for different white ethnic groups, though the distinctions were less severe than racial ones. English Protestants sat atop the hierarchy. Irish Catholics, Germans, and other immigrant groups faced legal discrimination, limited political rights, and harsher treatment by courts, but they retained the fundamental status of legal personhood denied to people of African or indigenous descent. Over time, the definition of white expanded to include these groups, demonstrating that racial categories were legal and social constructions rather than biological realities. By the mid-1700s, British North America had developed a comprehensive legal framework that systematically discriminated based on race and ethnicity. This wasn't just a few bad laws or prejudiced individuals. It was a complete reimagining of English legal traditions to serve the economic and social needs of a colonial society built on slavery and indigenous dispossession. The principles of English common law, trial by jury, right to testify, property rights, proportional punishment, applied fully to elite white men, partially to poor white men and white women, minimally to indigenous people, and virtually not at all to people of African descent. This was the legal landscape when crimes occurred, and it determined everything about how different groups experienced justice. In the spring of 1682, an enslaved man named Marmaduke was accused of a capital crime in Northumberland County, Virginia. He had allegedly struck his overseer, a white man named Mr. Pritchett, with a hoe during a dispute over work assignments. Pritchett survived the blow with only a bruised arm, but the mere act of an enslaved person striking a white person constituted a capital offense under Virginia law. The trial that followed illustrates the complete absence of legal protections for enslaved people. Marmaduke was not tried in the county's regular court, where white defendants appeared before juries of their peers. Instead, he was tried before a special tribunal of Oyer and Terminer, a panel of justices of the peace convened specifically to try enslaved people accused of serious crimes. There was no jury. Marmaduke had no legal representation. He could not call witnesses in his defense because, enslaved people's testimony was inadmissible in any case involving white people. The entire proceeding took less than an hour. The prosecution called Pritchett, who testified that Marmaduke had struck him maliciously and without provocation. No cross-examination occurred. No evidence was presented about the working conditions or what might have precipitated the incident. Marmaduke was allowed to speak. He insisted he had only raised the hoe defensively when Pritchett came at him with a whip, but his words carried no legal weight. The tribunal found him guilty and sentenced him to death by hanging. But here's where the case becomes even more revealing. Marmaduke's owner, a wealthy planter named William Clapham, protested the execution. Not because he believed in justice for Marmaduke, but because execution would deprive him of valuable property, a healthy young enslaved man worth approximately 30 pounds. Clapham petitioned the tribunal to commute the sentence to severe whipping instead. The tribunal refused, citing the need to make an example that would deter other enslaved people from insolence toward whites. Clapham then petitioned the colonial government for compensation for his loss. Under Virginia law, when an enslaved person was executed for crime, the colonial government was required to compensate the owner for the value of their property. This created a perverse situation. The enslaved person lost their life, but the owner was made whole financially. The system literally put a price on black lives, and that price was paid not to black people, but to their white owners. Marmaduke was hanged in June 1682. His body was quartered and displayed at crossroads around the county as a warning. Records show that during the same court session, 3 white men were convicted of assault, actual serious assaults, not defensive gestures, and each received between 10 and 20 lashes. None were executed. None faced having their bodies mutilated and displayed. The case demonstrates how colonial justice operated as a mechanism of racial terror, using extreme violence to enforce absolute submission of enslaved people to white authority. Every aspect of the process, separate courts, inadmissible testimony, absence of legal representation, disproportionate punishment, and the public display of mutilated bodies, was designed not to achieve justice, but to maintain white supremacy through fear. The treatment of Native Americans under colonial law, or more accurately, their exclusion from colonial law, is starkly illustrated by the Gnadenhutten massacre, one of the most horrific episodes of frontier violence against indigenous people. In March 1782, a group of approximately 96 Christian Delaware Indians were living peacefully at Gnadenhutten, a Moravian mission settlement in what is now eastern Ohio. These were converted Christians who had explicitly rejected involvement in the ongoing violence between American settlers and indigenous peoples during the Revolutionary War. They farmed, attended church services, and attempted to live according to European Christian standards. A militia of 160 men from Washington County, Pennsylvania, led by Lieutenant Colonel David Williamson, rode to Gnadenhutten under the pretense of providing protection to the Delaware community from hostile raiding parties. When they arrived, they gathered the Delaware, men, women, and children, into 2 buildings, supposedly for a religious service. Then Williamson addressed his militia. He explained that they had come to kill Indian prisoners in retaliation for raids conducted by completely different indigenous groups against Pennsylvania settlements. The militia voted on whether to massacre the Delaware. Of 160 men, only 16 voted against. The others voted to proceed with what they called execution of justice. The Delaware were given the night to pray. Many spent it singing hymns. The next morning, the militia systematically murdered 96 people, 28 men, 29 women, and 39 children, using mallets to crush their skulls, a method chosen to save ammunition. The bodies were then burned in the mission buildings. This wasn't a spontaneous act of violence in the heat of battle. It was premeditated, organized, and deliberate. It was also completely legal under the prevailing understanding of colonial law regarding indigenous peoples. Here's why. Colonial legal systems generally recognized indigenous peoples as members of foreign nations, not criminals, but enemies. This meant that treaties could be signed with them, but it also meant that European rules of warfare often didn't apply. The laws of war that supposedly governed conflicts between European powers, prohibitions on killing noncombatants, respect for prisoners, and so forth, were rarely extended to conflicts with Native Americans. After the massacre, some Moravian missionaries attempted to bring charges against Williamson and his militia. The effort went nowhere. When the case finally reached a frontier court, Williamson was acquitted after less than an hour of deliberation. The reasoning was straightforward. The Delaware were enemy Indians, and therefore killing them, even as noncombatants who had renounced hostilities, fell under the rules of frontier warfare rather than criminal law. No militia member ever faced meaningful legal consequences. Contrast this with how colonial authorities treated whites who killed other whites. In 1781, just a year before Gnadenhutten, a Pennsylvania settler named Robert Mays murdered his neighbor over a land dispute. Mays was arrested, tried before a jury, convicted, and hanged, all within 3 months. The legal system functioned exactly as designed when the victim was white. When the victims were indigenous, even 96 innocents including 39 children, the system simply didn't engage. The Gnadenhutten massacre reveals how the exclusion of indigenous peoples from legal protection effectively gave white colonists license for genocide. The absence of formal police meant that frontier militia, essentially armed white male citizens, served as the primary instrument of racial violence against Native Americans, operating with complete impunity. The massacre wasn't a breakdown of the legal system. It was the system working as designed, to enable territorial expansion through indigenous removal and destruction. In the spring of 1741, New York City was gripped by conspiracy panic that resulted in one of the most disturbing legal proceedings in colonial history, demonstrating how racial fear could transform the legal system into an instrument of mass terror against black and poor white populations. A series of fires broke out in Manhattan, destroying several buildings including the governor's residence. In a city where roughly 20% of the population was enslaved, and where memories of a 1712 slave uprising remained vivid, authorities immediately suspected an organized conspiracy of enslaved people plotting rebellion. What followed was a legal nightmare that revealed the complete absence of due process protections for accused black people, and the ease with which poor whites could also be swept up in racial panic. The investigation was led by judges and prosecutors who used torture, coerced testimony, and promises of leniency to extract confessions and accusations. A white indentured servant named Mary Burton became the prosecution's star witness, claiming knowledge of a vast conspiracy involving dozens of enslaved people and poor whites plotting to burn the city and massacre its white residents. Her testimony shifted and expanded with each interrogation, eventually implicating more than 150 people. The trials that followed were characterized by legal procedures that would be unrecognizable today. Enslaved defendants had no right to legal counsel, couldn't testify on their own behalf, and faced all-white juries already convinced of their guilt. The prosecution relied heavily on testimony from other enslaved people, testimony that had been extracted through torture, threats, and promises of leniency that were later broken. Confessions were obtained through waterboarding, prolonged isolation, and explicit threats that confession offered the only hope of avoiding burning alive, the most feared method of execution. The sentences were staggering. 17 black men were hanged, 13 were burned alive, and 70 were transported, sold to brutal plantation slavery in the Caribbean, effectively a death sentence. 4 white people, including 2 men and 2 women of Irish and lower-class backgrounds, were also hanged, a rare instance where poor whites faced capital punishment alongside black people, illustrating how racial panic could temporarily override some class privileges. But here's what makes the case especially revealing. Compare it to how authorities handled accusations against wealthy or prominent whites. During the same period, several wealthy white men were accused of various crimes including assault, fraud, and even manslaughter. Their cases proceeded through regular courts with full legal protections, jury trials, and in most cases resulted in acquittals or minor penalties. Class and race created entirely different legal universes even within the same city. The conspiracy trials also revealed how legal testimony was valued differently based on the witness's race. White witnesses, even indentured servants like Mary Burton, were considered credible. Their testimony alone could condemn others. Enslaved people couldn't testify against whites but could be coerced to testify against other enslaved people. Testimony extracted under torture that would be completely inadmissible if the defendant were white. Modern historians largely agree that no actual conspiracy existed, at least not on the scale described. The fires were likely accidental or the work of a few individuals at most. What occurred was a racial panic that transformed normal legal proceedings into a mechanism of terror, demonstrating how the absence of legal protections for black people could enable mass murder under the color of law. While most discussions of colonial justice focus on the 1600s and 1700s, the systems established then persisted well into the 19th century. The Los Angeles Chinese Massacre of 1871 demonstrates how legal discrimination against ethnic minorities continued even as the United States supposedly developed more formalized legal institutions. In October 1871, Los Angeles had a Chinese population of about 200 living in a neighborhood called Negro Alley, itself a telling name. On October 24, a dispute between Chinese residents led to gunfire that killed a white police officer who intervened. Within hours, a mob of approximately 500 white and Hispanic residents descended on the Chinese neighborhood. Over the course of several hours, they lynched 18 Chinese men and boys, some as young as 15. The victims were dragged through streets, tortured, and hanged from makeshift gallows while a crowd of spectators watched. Some victims' fingers were cut off to steal their rings before they were killed. The massacre occurred in a city with police, courts, and formal legal institutions. Yet these institutions utterly failed to protect the Chinese community or prosecute the perpetrators. Why? Because California law explicitly discriminated against Chinese residents in ways that created a legal environment enabling such violence. California's 1850 Act for the Government and Protection of Indians and the 1863 Act to Protect Free White Labor explicitly excluded Chinese, indigenous, and black people from testifying against whites in court. This meant that even though hundreds of witnesses saw the massacre, none of the Chinese survivors could legally testify about what happened. The prosecution had to rely entirely on white witnesses, members of the same community that had perpetrated the violence, who unsurprisingly suffered collective amnesia about who had done what. Initially, 10 men were convicted of manslaughter. They received sentences ranging from 2 to 6 years. But even these minimal consequences didn't last. On appeal, the convictions were overturned on a technicality. The indictments had failed to specify that the victims were human beings, a requirement of California law. The legal system's casual dehumanization of Chinese victims was so complete that it appeared even in technical legal documentation. The men went free. No one else was ever charged. The aftermath revealed how legal discrimination enabled community violence. Chinese residents who had lost family members couldn't sue for damages because they couldn't testify. Merchants whose shops were looted during the violence couldn't recover losses for the same reason. The message was clear. Chinese lives and property had no protection under American law. The massacre also demonstrated how ethnic hierarchies extended beyond the black-white binary of slavery-era laws. California had developed a comprehensive system of anti-Chinese legislation, laws prohibiting Chinese immigration, land ownership, interracial marriage, and access to citizenship. The 1871 massacre wasn't an aberration. It was a natural outgrowth of a legal system that explicitly marked Chinese people as less than human and outside the law's protection. The radically unequal treatment of different ethnic groups under colonial and early American law created social consequences that reverberated for centuries and continue to shape American society today. Perhaps most significantly, the differential legal treatment of ethnic groups created and enforced a racial caste system that outlived the specific laws that created it. When law defines some people as less than fully human, unable to testify, own property, or receive equal justice, it doesn't just constrain those individuals. It creates social categories that persist in culture, economics, and community attitudes long after the explicit laws disappear. The descendants of enslaved Africans inherited not just poverty, but a social position defined by centuries of legal dehumanization. Even after slavery's abolition, Black Americans faced laws, black codes, Jim Crow, restrictive covenants, and more, that continued the pattern established in colonial slave codes, using law to create and enforce racial hierarchy. The straight line from colonial slave patrols to modern policing of black communities reflects this continuity. Similarly, indigenous peoples' legal treatment as outside American law enabled and justified genocide, forced removal, and cultural destruction. The legal fiction that Native Americans were members of foreign nations allowed the federal government to sign treaties while simultaneously denying indigenous people citizenship, legal protection, or meaningful sovereignty. This contradiction enabled the theft of an entire continent while maintaining the appearance of legal process. Differential legal treatment required and reinforced psychological dehumanization. When your legal system says that a black person's testimony is worthless, that Native Americans can be killed without legal consequence, that Chinese people aren't fully human in the eyes of law, it shapes how people think about themselves and others. White colonists didn't need to be individually cruel or racist, though many were, to participate in systems of racial oppression. The law told them that people of color were fundamentally different, less deserving of protection, and potentially dangerous. This legal framework shaped cultural attitudes, religious justifications, and economic structures. The law didn't just reflect prejudice, it created and perpetuated it. For people of color, experiencing this legal inequality created trauma that passed through generations. When your grandfather was legally prohibited from testifying against a white person who murdered his wife, when your grandmother could be whipped for learning to read, when your parents couldn't own land or become citizens, it shapes your relationship with legal authority, your trust in institutions, and your understanding of your place in society. Legal discrimination had enormous economic consequences that compounded over generations. When enslaved people couldn't own property, accumulate wealth, or pass inheritance to children, they started emancipation with nothing. When Native Americans were legally prohibited from owning land in fee simple and were subjected to allotment policies designed to divest them of territory, they lost their economic base. When Chinese immigrants faced laws prohibiting them from owning land, working in many professions, or bringing their families to America, their economic opportunities were deliberately constrained. These weren't just historical injustices, they're the foundation of contemporary wealth inequality. Wealth compounds across generations. The white family that acquired land, often stolen from indigenous people or worked by enslaved people, in 1700 could pass that wealth through generations, each one building on the previous. The black family legally prohibited from property ownership until 1865, then subjected to another century of legal discrimination in lending, housing, and employment, never got that same opportunity for compound wealth growth. One crucial but often overlooked consequence of racial legal inequality was that it created common interest between wealthy and poor whites. Poor white men might lack land, wealth, or political power, but they had something invaluable, legal personhood and privileges denied to people of color. This created solidarity across class lines that might otherwise have fractured white society. A poor white indentured servant and a wealthy plantation owner might have opposed economic interests, but both benefited from a legal system that protected them from enslaved people's testimony, gave them power over black and indigenous people, and marked them as superior regardless of their economic status. This psychological wage of whiteness, the benefit of not being at the very bottom of the social hierarchy, helped prevent class-based coalitions between poor whites and people of color that might have challenged the colonial elite's power. Perhaps most insidiously, building racial inequality into law corrupted the very concept of legal justice. When courts exist partly to dispense justice and partly to enforce racial hierarchy, they can't effectively do either. This created cynicism about law among both privileged and oppressed groups. The privileged saw law as a tool for controlling others rather than a neutral arbiter of justice, while the oppressed saw law as an instrument of oppression rather than protection. This corruption spread throughout legal culture. Lawyers learned to navigate racially discriminatory laws. Judges enforced them without apparent moral qualms. Communities watched legal proceedings they knew were travesties of justice and either participated or remained silent. This normalized legal injustice in ways that made even well-intentioned reform difficult, because the entire culture of law had adapted to serve inequality. The colonial patterns of racially discriminatory justice didn't end with colonialism. They evolved, adapted, and persist in contemporary American legal systems in ways both obvious and subtle. Perhaps the most direct modern connection is the astronomical racial disparity in American incarceration. Black Americans represent 13% of the U.S. population, but nearly 40% of the incarcerated population. This disparity mirrors colonial patterns, where the same act received radically different treatment based on the offender's race. Today, we see it in phenomena like the infamous 100-to-1 sentencing disparity between crack cocaine, associated with black users, and powder cocaine, associated with white users. The same drug, different forms, wildly different legal consequences based on the race of typical users. Studies consistently show that black defendants receive longer sentences than white defendants for identical crimes with identical criminal histories. Black children are more likely than white children to be tried as adults. The death penalty is disproportionately applied to people of color, especially when victims are white. These aren't historical artifacts. They're ongoing patterns that directly descend from colonial legal systems designed to treat different races differently. While we've abolished laws explicitly prohibiting people of color from testifying, the legacy persists in more subtle forms. Studies show that juries give less credibility to testimony from black witnesses than white witnesses. Police are less likely to believe black crime victims. The entire system of credibility determinations, who gets believed, still follows racialized patterns established when black testimony was legally worthless. This is particularly stark in police violence cases. When a black person says they were abused by police, and the police offer a contradictory account, whose version is believed by prosecutors, juries, and the public, the pattern of skepticism toward black accounts mirrors the colonial principle that black voices simply carried less weight than white ones. The colonial pattern of treating indigenous peoples as outside American law continues in the complex, contradictory status of tribal sovereignty. Native Americans are simultaneously citizens of the United States, members of sovereign nations, and subjected to federal plenary power that can override tribal authority at congressional whim. This legal limbo descends directly from colonial ambiguity about whether Native Americans were subject to colonial law or outside it. Contemporary issues: missing and murdered indigenous women receiving minimal law enforcement attention, inadequate resources for tribal law enforcement, and jurisdictional confusion that leaves crimes unprosecuted. all reflect the colonial pattern of excluding indigenous peoples from legal protection. The modern system has more complexity and bureaucracy, but the fundamental problem remains. Indigenous lives and indigenous justice don't receive the same priority as white lives and justice. The treatment of immigrant communities, particularly Latinx and Muslim communities, echoes colonial patterns of creating legal categories that expose certain ethnic groups to harsher treatment. Programs like Show Me Your Papers laws in Arizona, which effectively criminalize appearing Latinx in public, mirror colonial slave patrols that demanded black people produce passes, proving they had permission to be off their owner's property. The differential treatment of undocumented immigrants based on nationality. Cuban immigrants received preferential treatment compared to Mexican immigrants, for example, reflects the colonial pattern of creating legal hierarchies among different ethnic groups. The use of immigration enforcement to raid workplaces, separate families, and deport long-term residents without criminal records demonstrates how law continues to be used as a tool of ethnic control rather than neutral justice. Modern restorative justice movements represent, in part, an attempt to reconnect legal systems with community-based approaches that might have existed before colonial systems imposed European legal frameworks. Many indigenous communities advocate for restorative rather than punitive justice, drawing on traditions that predate colonization. These approaches recognize that colonial legal systems were designed to oppress and control indigenous peoples, and that justice for these communities requires fundamentally different frameworks. However, this raises complex questions. Can restorative justice work in a society still structured by racial hierarchy? Colonial community justice was often vigilante terror against people of color. How do we distinguish legitimate community-based justice from mob rule? These debates force us to grapple with whether reforming discriminatory systems is sufficient or whether we need entirely new approaches to justice. Growing movements calling for prison abolition or police abolition are, in part, responding to the recognition that contemporary legal institutions descend from systems designed to enforce racial hierarchy. Abolitionists argue that reform is insufficient because the fundamental architecture of American legal systems, from policing to prosecution to incarceration, was built to control people of color. They point to the direct lineage from slave patrols to modern police, from slave codes to modern criminal codes, from plantation discipline to prison labor. These arguments force difficult questions. Can institutions built on racial oppression be reformed to serve racial justice? Or do we need to fundamentally reimagine what justice looks like, building new institutions without the corrupt foundations of colonial law? The colonial history we've explored gives these questions urgency and weight. As we've journeyed through the brutal history of racially discriminatory justice in colonial and early America, we've witnessed the deliberate construction of legal inequality, a system that made justice dependent not on guilt or innocence, evidence or truth, but on the color of your skin and your place in an artificially created racial hierarchy. Marmaduke, hanged for defensively raising a hoe against an overseer's whip, while white men convicted of actual assaults received lashes and walked free. 96 Christian Delaware, including 39 children, massacred at Gnadenhutten, while their killers faced no legal consequences. The New York conspiracy trials where confessions were tortured out of enslaved people, resulting in 17 hangings and 13 burned alive. Chinese victims of the 1871 Los Angeles massacre, whose killers went free because Chinese testimony had no legal value. These aren't isolated tragedies. They're the logical outcomes of legal systems designed to dehumanize, control, and terrorize. What makes this history so disturbing isn't just the brutality, though that alone is horrifying. It's the deliberateness. The inequality wasn't a bug in the system. It was the system. Legislators carefully crafted laws making identical crimes carry different punishments based on race. Courts created separate proceedings for enslaved people that stripped away every protection. Communities organized slave patrols and militias whose explicit purpose was racial control. Generation after generation of colonial Americans participated in, enforced, and accepted these systems, not because they were all individual monsters, but because the law told them this was right, proper, and necessary. The legal architecture built during these centuries didn't disappear with emancipation or civil rights legislation. It evolved. The slave codes became black codes, became Jim Crow, became mass incarceration. The slave patrols became police departments that still disproportionately stop, arrest, and use force against people of color. The testimonial exclusions became credibility determinations that still doubt black voices. The legal dehumanization became cultural assumptions embedded so deep we barely notice them. Understanding this history is essential, not to assign guilt or shame to modern individuals for their ancestors' actions, but to recognize how the past shapes the present. When we see racial disparities in arrest rates, sentencing, police violence, and incarceration, we're not witnessing isolated instances of individual prejudice. We're seeing the continued operation of systems designed, from their inception, to treat different races differently. The machinery may have been updated, but it's still running on the same blueprints drawn in colonial Virginia, Massachusetts, and Carolina. This recognition should be neither paralyzing nor despairing. It should be clarifying. It tells us that tweaking the current system isn't enough because the current system's architecture is built on oppression. It tells us that individual bias training won't solve problems that are structural rather than personal. It tells us that meaningful change requires not just different policies, but fundamentally different approaches to what justice means and how we achieve it. It also tells us something hopeful. These systems were built by human choices, and human choices can unbuild them. Nothing about racial hierarchy in law was inevitable or natural. It was created deliberately to serve economic and political purposes. If it was created, it can be uncreated. If it was built, it can be rebuilt. So we ask you, what does justice look like in a society built on injustice? Can institutions designed to oppress be reformed to liberate, or must they be fundamentally reimagined? How do we honor the memory of Marmaduke and the Gnadenhutten victims and the New York conspiracy victims and the Chinese massacre victims, not with empty words but with systems that truly deliver equal justice regardless of race? And what role do each of us play in either perpetuating or dismantling the legal legacies of colonial racial hierarchy? These aren't comfortable questions. They shouldn't be. Comfort is what allows unjust systems to persist. Discomfort is what drives change. We'd love to hear your thoughts. How do you see colonial patterns of racial injustice reflected in modern legal systems? What do you think needs to change? Reform or fundamental reimagining? How do we move from a legal system built on racial hierarchy to one that truly delivers equal justice? Share your perspectives in the comments below. If this deep dive into the racial foundations of American legal systems has challenged your thinking or taught you something new, please like this video and subscribe to our channel for more explorations of historical topics that continue to shape our present. Next time, we'll be examining another often overlooked aspect of early American justice systems that continues to resonate today. Until then, remember, those who ignore history are condemned to repeat it, but those who study history critically are empowered to change it. Thank you for watching, and we'll see you in the next documentary.